Did you prepare the report?
Oh, no, sir. But I believe
Ms. Johnson did.
That's right.
Okay.
I believe the orders would be in the file for potential.
I understand.
Yes.
Okay. All right. Anything else from the state?
Nothing further from the state, Judge.
Defense.
Judge, as a practical matter, I want to alert the court that we were concerned the court pronounced sentence on the day of the conviction and the day of the punishment hearing. And we were concerned that this hearing was placed after 30 days from that date. And so we have already filed a notice of appeal, and the case is pending before the Court of Appeals. Obviously, the court can impose, I would ask there's no reason to impose a jail time sentence or a cognitive tract sentence as part of the probation. Mr. Hardy has been faithfully attending court and doing everything he's supposed to be doing, for 4 years now, and has not been a problem, has not had other allegations of anything. He's been a model citizen. He's kept a job. He's done everything that he would have been doing on probation. And so it seems like there's no reason to add that sort of punitive aspect to this when the jury intended for him to get probation. But additionally, if the court were to impose that, we're asking that be suspended until the outcome of the appeal. As the court is aware, and again, they kind of keep changing the rules, and so we may need to double check what the rule is. But my understanding is that if he's granted probation by the jury, then the notice of appeal holds the probation in abeyance pending the outcome of that appeal. And we're asking the court to follow that here, regardless of what the court orders in terms of specific probation orders.
Yeah. Anything from the state? Because I don't disagree with that.
Judge, I need 10 minutes to verify.
They're appealing. They've appealed the judgment, but nonetheless, the court has to set orders in the meantime that are in the best interest of justice.
Sure.
Under this, that would protect not only the complainant victim here in this case, but also ensure that the defendant does not make a mistake while on bond, in this case, pending the outcome of the appeal. And so there will be terms and conditions of probation that will be set to ensure that everything is frozen as far as
Judge.
from the moment of the a conviction by the jury verdict. And these terms and conditions that have been recommended here in this pre-sentence report, court will order that the defendant is to be placed on intensive supervision probation sex offender caseload, ordered to comply with all sex offender conditions of probation and requirements, will not be allowed to have any contact with the complainant victim nor her immediate family, or be allowed on the premises where the complainant victim resides, attends school, or place of employment. Also, this is recommended that the defendant shall serve upfront jail time and to enter and successfully complete the cognitive track of the intermediate sanction facility. The requirement of completing the cognitive track of the intermediate sanction facility is going to be ordered. What does the state say on upfront jail time? Does I know what they're going to say?
The state has requested, just as the probation department recommends either or, the state is asking that the court follow that recommendation of whichever one the court chooses to serve upfront jail time or be ordered for the cognitive track of the intermediate sanction facility.
Okay. You disagree with that?
Well, also, Judge,
Obviously.
but
I mean, that's
More
what you argued.
importantly, we're asking that, obviously, that would be imposed only if the appeal is unsuccessful.
All right.
And that's something, as the court knows, that you can order at any time during the course of his probation, should his appeal be.
Well, the court's going to make some orders in the meantime to freeze everybody. You shall have no contact with the complainant victim, nor anyone on your behalf, unless through this court, and be placed on the intensive supervision probation sex offender caseload. How do we do that in this meantime?
Judge, I think you would just make conditions of bond, essentially.
Yeah. Once again, how do I supervise him on just a bond? There's no supervision there. The court has to know that he hasn't fled.
Yeah.
You know, and does not have a contact.
Judge,
I've got an idea, but what do you want to say?
well, I was going to propose, if you allow him to actually just stay like he's on probation, be on probation right now, report to the probation office like he would, pay those probation fees and do sex offender registration for now. And then we'll hold the other stuff in abeyance until the outcome of the appeal. And that way we're not having to come back in, a year or two and redo all of this.
Probation office, see where we are on this. It's because a trial and an appeal, and that freezes that in time.
We can work.
But the court is also allowed under the law to make conditions of supervision and conditions of release based upon his bond that are similar to what would be necessary conditions to ensure that there isn't a problem of that the defendant faces, nor the child victim faces during the interim. So it will include no contact with the child, nor anyone on your behalf, except through probation and with the permission of the state if something like that happens. Generally, we never need that. The court generally follows the recommendations of the probation office and doesn't seem, none of these recommendations seem unusual, nor inappropriate, but they obviously can't all be assessed at the same time until the appeal is resolved. Is there anything through the probation office or through the state that you see here in the proposed recommendations that need to be dealt with while the appeal is pending?
Judge, I'm okay with holding off until the appeal is complete and holding those things in abeyance. The only other thing I'm going to ask is, as far as sex offender conditions and based on the type of offense this was, his contact with persons 17 years of age or younger, I'm going to ask that he not be allowed to be in contact with children 17 years of age or younger.
I think technically it's a child younger than 17 years is the point involving these types of cases where it would be forbidden. So
may I ask then that we, at least for the purposes of while the appeal is pending, that be that the modifier of unsupervised to be placed in that. In other words, seemingly at weddings or family gatherings or something like that, where there's a bunch of people around, that there's not really a risk based on the allegations in a case like this.
You know how many cases we have in here where the family members have been assaulted, what, and who's to, that's, if something happens, who wants to answer to the big headline? Who's to blame now? No,
You blame me, Judge.
that's not the way it's going to work. And public perception being what it is, it's important because the people want to know that the laws work properly, fairly, and also to do what can be done to ensure that there's no further harm. And that's something bad happens to someone younger than 17, but he's got family, close family, right?
Yes,
I don't know what I can do about it.
Sitting right here.
Yeah, I'm not sure what I can really do about a sibling,
Right.
not having contact with a sibling.
Well, all of his siblings are,
But other than an immediate family,
okay,
the defendant is disallowed from having contact until this moves on. And
Is the court saying that he can have contact with immediate family members that are under 17?
what's the answer to that? I mean, does he live in the household with?
he does not, Judge, but I can't foresee what's going to happen,
Well, because of the facts of this case, and it was an immediate family member under 17, I'm going to ask that he not be able to have contact with any
I'm
children.
afraid that's a problem. I'm afraid it is under the circumstances.
Well,
If it was anything other than that, I would have been, I'd be more lenient. But once again, a jury found the defendant guilty of the sexual assault of a young relative, immediate relative. I'm sorry, we're going to have to freeze the action and freeze all of this, which means no contact
Okay,
with someone younger than 17.
we understand, Judge. We'll comply with that.
And what else do we need to deal with?
I don't think there's anything else.
Let me just say this too. A condition of probation at the end when this is resolved, if it is resolved as a affirmed ruling in this case, the defendant is going to be ordered to serve 180 days in the county jail as a condition of your probation. Otherwise, the seriousness of this type of offense would be minimized, and it's not minimized on this court's watch. Sexual assault of a child, the price of the loss of innocence of a child has no figure to it. It's priceless, and it has to be dealt with by leadership to show that the people understand, appreciate the importance of the innocence of a child. So that will be a condition of your probation when this bond comes out, when this appeal review is completed. I think probably we're going to have to take up a matter of other conditions of probation
At that time.
at that time, yeah, because depending upon the outcome,
Yes.
it can go this way or that way on.
Right. Right.
Oh, and also what the defendant's status is in jobs and other things.
Yes, sir. I understand.
So
Thank you,
what do we need to do next?
I think that
We need to set just something. for
finalize
review.
orders, finalize orders that say that any ISF or the upfront time is held in advance, pending the outcome of the appeal.
Okay.
And then,
Can we do this in 2 weeks?
No, sure.
Okay, let's reset in 2 weeks for finalization of all of this, okay? And a review of status. Thank you.
thank you, Judge.
Get a resetting. That is all. Here, let's see another one. All right, we have a trial. Well, let's get ready.
Judge, we need to address Pauletta Powell.
Okay, I'll let it out.
Just free bill.
Yes. Get resetting though. Did I give you her file back? Hold on.
We won't say this, but we can say
I was trying to think.
Status hearing. Status hearing.
yes, Judge.
Okay, go ahead. What are we, what's the status?
Judge,
I want to hear.
we think we've got a resolution.
What do we want to do today?
We want to reset it maybe 2 weeks.
Yes, that's fine.
Or, she needs to confirm the resolution
Okay.
with the
Is
complaints
that
in the
good
case.
for this day?
Sounds good.
Sounds-
Okay. Thank you. Judge, may I have 5 minutes to talk about two families?
No, you got 10,
Thank you.
whatever you, yeah.
Okay, thank you.
Okay, thanks. We are in recess. Short recess and we'll pick up the trial. Thank you. Stand by.